Drug laws usually mean prison time and long sentences. The people behind these crimes are treated as criminals to be locked away, and not as offenders facing the ultimate punishment. However, the cases we're covering today were different. These weren't accidents or mistakes. Instead, they were planned choices made by people who knew exactly how much harm they would cause. And when their actions crossed a line the law couldn't ignore, courts had to decide how far justice should go. Today, we're looking at cases that tested those limits. Case 1. Juan Raúl Garza, United States. Juan Raúl Garza was born in November 1956 in Texas, near the border with Mexico. He grew up understanding how goods moved between the two countries without detection. During the 1980s and 1990s, Garza ran a construction company in Brownsville, Texas. At the same time, he operated a network that moved substances from Mexico into Texas, Louisiana, and Michigan. The construction business provided cover while the illegal operation expanded. As the network grew, disputes emerged over shipments, money, and loyalty. Garza responded with violence. Between 1990 and 1992, he was responsible for multiple killings connected to his operation. 3 happened in the United States. At least 4 more occurred in Mexico. Court records show that on August 10, 1993, Garza was sentenced to death in the Southern District of Texas. The federal government convicted him under the Anti-Drug Abuse Act of 1988. This law allowed capital punishment for killings committed as part of ongoing criminal enterprises. After a decade of appeals, he was put to death by lethal injection on June 19, 2001, at the Federal Correctional Complex in Terre Haute, Indiana. His execution came just 8 days after Timothy McVeigh's death, ending a 38-year federal pause on capital punishment. Federal court documents reveal that Garza entered distribution networks during the late 1980s. Texas border towns provided access to suppliers in Mexico. His construction business created the appearance of legitimate work, while money moved through separate channels. As operations expanded, Garza employed workers who inspected shipments, transported loads, and maintained locations. Federal officers later documented shipments exceeding 1,000 kilograms. The network stretched across state lines, reaching markets in Louisiana and Michigan. Control required enforcement. When workers failed to protect shipments or when disputes arose over lost money, Garza used violence. Associates learned that mistakes carried severe consequences. However, this also created a pattern of killings that would later form the basis for capital charges. Witness testimony presented at trial shows that Garza personally carried out some of the acts. In other cases, he ordered subordinates to do so. Each incident served to eliminate individuals who threatened the operation's security or profitability. By 1990, federal prosecutors state, Garza's willingness to use violence had become central to how he maintained power within the organization. Court records reveal that in April 1990, Garza was responsible for the death of Gilberto Matos. The victim worked within Garza's organization. Federal investigators later identified this as one of 3 incidents that would form the core of Garza's capital conviction. In January 1991, Thomas Rumbo became Garza's next victim. Trial testimony indicates that Rumbo, age 35, worked for Garza inspecting trucks. Federal officers observed Rumbo loading 360 pounds into a trailer. When confronted, Rumbo agreed to turn over the shipment. He attempted to cover this by cutting a hole in a fence and claiming the goods were taken. Witness testimony shows that Garza did not accept this explanation. He drove to Rumbo's house with 2 workers and forced Rumbo into his truck. As they drove, Garza made 2 stops. At the first stop, one of his workers provided Garza with a weapon. At the second stop, another associate joined them. During the drive, they questioned Rumbo, but he maintained his story. They eventually arrived at a rural farm road. Testimony reveals that Garza then took Rumbo's life. The third incident involved Erasmo de la Fuente. Prosecutors note that this act emerged from disputes within Garza's operation. The pattern was consistent. Each victim had either failed in their duties or posed a threat to Garza's control. These three incidents, all linked directly to the illegal operation, would become the legal foundation for Garza's death sentence. Federal court documents show that authorities initially arrested Garza on trafficking charges. The investigation centered on his operation, and prosecutors built their case around the movement of illegal goods across state lines. Evidence documented the scale of Garza's enterprise and his role as the organization's leader. As the investigation continued, witnesses began cooperating with federal officers. Trial records indicate that associates within Garza's network provided testimony about the violent acts. Some cooperators have participated or had direct knowledge of how they were carried out. Their statements connected Garza to specific victims and described the circumstances that led to each incident. Based on this evidence, court filings reveal that federal prosecutors added charges related to the violent acts to the existing trafficking indictment. The government alleged that Garza had committed 3 such acts in furtherance of a continuing criminal enterprise. Prosecutors also introduced evidence suggesting Garza was responsible for at least 5 additional incidents in Mexico, though he was never formally charged with those in Mexican courts. The case moved to federal court in the Southern District of Texas. The Department of Justice states that prosecutors announced they would seek the death penalty under the Anti-Drug Abuse Act of 1988. This law permitted capital punishment for violent acts committed as part of ongoing trafficking operations. Federal authorities transferred Garza from Texas state custody to federal prison, preparing him for trial on capital charges. Trial transcripts show that the prosecution's case relied heavily on testimony from co-conspirators. Multiple associates within Garza's organization agreed to testify in exchange for reduced sentences. These witnesses provided detailed accounts of how the violent acts were planned and executed. Their testimony described Garza's direct involvement. Physical evidence supported the witness accounts. Court records indicate that federal officers recovered transaction records that documented the scope of Garza's operation. Financial evidence showed the movement of money through the organization. These records corroborated testimony about the criminal enterprise and established Garza's leadership role. In addition to the 3 incidents in the United States, trial testimony reveals that prosecutors presented evidence about 4 unsolved cases in Mexico. Testimony indicated that Garza ordered the April 1991 incident involving Oscar Cantu in Reynosa. Witness statements show that Cantu, age 54, had lost tens of thousands of dollars of Garza's money. He told Garza that Mexican police had taken the money and harmed him. Cantu showed scars to prove his account, but testimony indicated Garza ordered him eliminated anyway. The evidence demonstrated a pattern of violence used to protect and expand Garza's operation. Testimony from a witness named Israel reveals that Fernando Escobar Garcia was killed in May 1991. Israel stated that Garza said he was going to eliminate Fernando because he no longer had use for him. That same month, Israel's testimony indicates that Garza ordered Israel to eliminate Lauro Antonio Nieto, who had lost $20,000 of Garza's money during a trip. Israel testified that Garza told him he was getting tired of Nieto, and that if Israel did not eliminate him, Garza would eliminate both of them. In January 1992, court documents show that Garza's son-in-law, Bernabe Sosa, age 21, was found deceased near the Rio Grande. The jury later found Garza responsible for this incident as well. Testimony and evidence linked Garza to all 4 Mexican cases, though Mexican authorities never prosecuted them. In 1993, court records revealed that Garza faced trial in federal court. The indictment charged him with 5 violations of federal trafficking laws, operating a continuing criminal enterprise, money laundering, and 3 counts related to violent acts in furtherance of that enterprise. Trial transcripts indicate that the defense strategy attempted to separate the violent acts from Garza's trafficking activities. Defense attorneys argued that the incidents should be viewed independently, rather than as integral parts of the operation. However, prosecutors successfully demonstrated that each act served to protect or advance Garza's criminal enterprise. The trial included extensive testimony from cooperating witnesses. Court documents show that former associates described the internal workings of Garza's organization and provided details about specific incidents. The prosecution presented evidence showing how Garza used violence to maintain control, eliminate threats, and punish failures within the network. Federal law permitted prosecutors to introduce evidence about the 4 incidents in Mexico as aggravating factors during sentencing. Though Garza was not formally charged with these acts, the law allowed their consideration to demonstrate the full scope of his criminal conduct. Garza became one of the first individuals sentenced to death under federal law since the modern era of capital punishment began. The jury found Garza guilty on all counts. Court records confirm that the conviction included the 3 charges related to violent acts that made him eligible for the death penalty. During the penalty phase, prosecutors emphasized the calculated nature of the incidents, Garza's leadership role in a major trafficking enterprise, and the additional acts in Mexico. The defense presented mitigating evidence about Garza's background and personal circumstances, but the jury recommended death. On August 10, 1993, official records show that the judge accepted the jury's recommendation and sentenced Juan Raul Garza to death on each of the 3 convictions. In addition to the capital sentence, Garza received a life term for conspiracy to import more than 1,000 kilograms of illegal substances into the United States. Following his conviction, court documents indicate that Garza exhausted all direct and collateral appeals. Courts repeatedly upheld his death sentence, finding no constitutional violations in his trial or sentencing. Department of Justice reports reveal that Garza's case raised questions about racial and geographic disparities in federal death penalty prosecutions. Statistics showed that minority defendants and certain geographic districts were disproportionately represented among those receiving capital sentences. In 2000, then Attorney General Janet Reno acknowledged these disparities and ordered a comprehensive study of the federal death penalty system. Official records show that Garza was initially scheduled for execution in December 2000. However, just days before the scheduled date, President Bill Clinton granted a 6-month stay. White House statements confirm that Clinton's decision came after reviewing the Department of Justice study on racial and geographic disparities in federal capital prosecutions. The stay pushed Garza's execution to June 2001. The Department of Justice reports that newly appointed Attorney General John Ashcroft reviewed the case in June 2001. Ashcroft concluded that no evidence of racial bias existed in Garza's sentencing. He pointed out that 7 of Garza's 8 victims were Hispanic. The prosecutor was Hispanic, the presiding judge was Hispanic, and at least 6 jurors were Hispanic. Court records show that victim impact statements presented during sentencing proceedings described the lasting harm Garza's actions caused to multiple families across 2 countries. On June 18, 2001, official records confirm that President George W. Bush denied Garza's clemency petition. Attorney General Ashcroft stated that Garza was guilty of both the U.S. incidents and the Mexican cases, and that there was no reason to delay the execution further. News reports indicate that Mark Patterson, one of the U.S. attorneys who prosecuted Garza, called him the most violent man I've ever prosecuted. On July 13, 1999, federal records indicate that authorities moved Garza from Texas State Death Row to the newly opened federal death row wing at USP Terre Haute in Indiana. He was one of 3 condemned inmates transferred that day. A little over 24 hours before his execution, official protocols reveal that guards transferred Garza to the holding cell adjacent to the execution chamber. His last meal consisted of steak, French fries, onion rings, 3 pieces of bread, and a Diet Cola. Reports indicate that Garza asked his family not to attend the execution. On the morning of June 19, 2001, official records show that guards escorted Garza to the execution chamber at the Terre Haute facility. The execution chamber was surrounded by a viewing room containing witnesses from the media and individuals involved in the case, including family members of his victims. Before the procedure began, witness accounts reveal that Garza made a final statement. he addressed both Warden Harley Lappin and the victims' families present. Reports indicate that Garza said, "I want to say that I'm sorry. I apologize for the pain and grief that I caused. I ask for your forgiveness, and God bless." Warden Lappin then read Garza's sentence aloud. Juan Raul Garza was pronounced deceased at 7:09 a.m. He was 44 years old. Federal records confirm that his execution ended a 38-year federal pause on capital punishment. Timothy McVeigh had been executed at the same facility just 8 days earlier. Garza became the second federal prisoner executed since 1963. Now, before we move on to the next case, make sure to subscribe if you're finding these stories as disturbing as I am. It helps us keep covering the cases that most channels won't touch. While Juan Raul Garza at least faced justice in an American court where he had legal representation and appeals, the next individual operated in a system so broken that he continued running his empire from inside maximum security prison. Case 2. Freddy Budiman, Indonesia. Freddy Budiman was born on July 18, 1977, in Surabaya, Indonesia. He grew up in East Java and later settled in Jakarta. Reports indicate that before entering illegal activities, Budiman worked in legitimate business, operating in the eyewear industry. Budiman's criminal career began with smaller operations before escalating to large-scale importation. Indonesian court records reveal that in 2009, authorities arrested him for possessing 500 grams of illegal substances. A court sentenced him to 3 years and 4 months in prison. While serving that sentence, later investigations show that Budiman did not stop his activities. Instead, he used his time in prison to develop new networks and plan larger operations. In 2011, police reports indicate that authorities arrested him again, this time for a far more serious offense. Police discovered Budiman was behind the importation of 1.4 million pills from mainland China. Indonesian court records confirm that a court in West Jakarta convicted Budiman in 2012 and sentenced him to death. The judgment reflected Indonesia's harsh stance on such crimes. However, later investigations reveal that Budiman's actions from inside prison would become as significant as the crimes that put him on death row. On July 29, 2016, at approximately 12:45 a.m., official records confirm that Freddy Budiman faced a firing squad at Panaluan Field on Nusa Kambangan Island in central Java. Police reports indicate that Budiman entered Indonesia's illegal trade during a period when synthetic substances were flooding Asian markets. Demand remained high, and profit margins attracted individuals willing to take risks. Court documents reveal that Budiman's first conviction in 2009 came after police found him in possession of 500 grams. The quantity exceeded personal use levels. Authorities processed him through the criminal justice system, and he received his sentence. Later investigations show that prison did not rehabilitate Budiman. Instead, incarceration provided opportunities he exploited. Using wealth accumulated from illegal profits, Budiman began corrupting prison officials. Testimony confirms that he paid for preferential treatment, including access to private rooms where he could conduct business. His partner later confirmed these arrangements in statements made before his execution. Investigations reveal that Budiman's ability to continue operations from inside prison demonstrated how corruption enabled his organization to function despite law enforcement efforts. Police reports indicate that from inside Cipinang prison, Budiman coordinated with individuals on the outside. He developed a network that allowed him to continue operations while physically confined. Authorities state that most troubling was that Budiman allegedly manufactured substances inside the prison facility itself. This revelation exposed systemic corruption within Indonesia's correctional system. Police investigations show that the organization Budiman built from prison expanded until authorities could no longer ignore it. In 2011, police arrested him for the importation operation. Investigators discovered Budiman had arranged for 1.4 million pills to enter Indonesia from China. The operation required international connections, sophisticated logistics, and corrupted officials at multiple points in the supply chain. Prosecutors note that the 2011 arrest marked a fundamental shift in how authorities viewed Budiman. The scale of the importation indicated he operated at the highest levels of trafficking. Indonesian prosecutors charged him with capital offenses, recognizing that his activities posed a national security threat. Evidence gathered during the investigation revealed the scope of Budiman's influence. Court documents show he had not simply arranged one large shipment. Testimony and financial records showed a sustained operation involving multiple parties across international borders. Budiman had access to suppliers in China, corrupt customs officials in Indonesia, and distribution networks throughout the country. Prosecutors emphasized that Budiman's wealth gave him the means to corrupt Indonesia's institutions. The government presented his case as emblematic of how illegal money undermined law enforcement and judicial processes. By 2012, when the West Jakarta District Court convicted Budiman, the Indonesian government had decided to frame major traffickers as existential threats to the nation. Indonesian law established that trafficking in quantities that exceeded specified thresholds carried a mandatory death sentence. Government statements reveal that during this period, Indonesia's government, led by President Joko Widodo, adopted an aggressive stance. Widodo repeatedly stated that Indonesia faced an emergency, with approximately 4.1 million Indonesians struggling with substance problems and 40 to 50 people dying daily from related issues. The government calculated that substance problems cost the country approximately 63 trillion rupiah annually in economic losses and social harm. Police reports confirm that officers arrested Budiman in April 2011 during coordinated operations. The arrest came after investigators tracked the shipment and identified Budiman as the operation's organizer. Officers found evidence linking him to the 1.4 million pills and to financial transactions that financed the importation. Following his arrest, court records indicate that authorities transferred Budiman to Cipinang Penitentiary, a facility designed to house high-level offenders. However, investigations reveal that Budiman's wealth and connections allowed him to continue his activities. Investigations later revealed he maintained a network even while imprisoned. Later reports show that the corruption extended beyond simple bribery. Budiman employed people from inside Cipinang to manage finances. One employee, identified as a British citizen named An Kal, allegedly handled funds from the business. Authorities state that his cell resembled an office, equipped with television and closed-circuit television monitors. In 2013, official records indicate that after being caught continuing operations from inside Cipinang, authorities transferred Budiman to Batu Prison on Nusa Kambangan Island. This remote facility, located off central Java's southern coast, was reserved for the most dangerous prisoners. Prison officials state that Budiman's transfer to Indonesia's most secure prison facility reflected authorities' recognition that he posed an exceptional security risk even while incarcerated. Reports indicate that during his time on death row at Nusa Kambangan, Budiman reportedly pledged allegiance to certain groups due to his association with other inmates housed on the island. However, the primary basis for his death sentence remained the trafficking conviction. Court documents show that the case against Budiman relied on multiple forms of evidence. Documentation showed how the 1.4 million pills moved from China to Indonesia. Police traced the logistics, identifying shipping routes, corrupt customs officials, and distribution points within Indonesia. Prosecutors note that financial records proved crucial. Investigators documented how money flowed through Budiman's network. Bank accounts and financial transactions showed Budiman receiving and distributing illegal profits. These records also revealed payments to officials, demonstrating the corruption that enabled his operations. Trial testimony indicates that witness statements added context to the documentary evidence. Associates who worked within Budiman's organization testified about his role. Some witnesses had direct knowledge of his instructions and his control over shipments. In 2014, reports confirmed that Budiman made a confession to Haris Azhar, a human rights investigator. Budiman stated that he had asked police the National Narcotics Agency, and the Directorate General of Customs and Excise to assist in importing substances into Indonesia. This confession indicated that corruption extended to the highest levels of law enforcement agencies. Investigations reveal that evidence gathered after Budiman's death continued to reveal the extent of his network and the institutional corruption that enabled his operations. The National Narcotics Agency reports that after Budiman's execution, authorities seized assets and 39 billion rupiah from suspects believed to be connected to his network. The operation, conducted in June 2017, targeted 4 suspects who allegedly laundered money on Budiman's behalf. Reports indicate that one suspect operated from inside Cipinang Penitentiary. Court records show that the West Jakarta District Court heard Budiman's case in a trial that examined both the importation and his earlier conviction. Prosecutors presented evidence about the 1.4 million pills and Budiman's role in organizing their entry into Indonesia. Defense arguments indicate that Budiman's attorneys argued that he did not deserve the death penalty. They pointed out that accomplices in the same operation received lighter sentences. Budiman's lawyer, Untung Sunario, emphasized this disparity during appeals. Prosecutors countered by demonstrating Budiman's leadership role. Evidence showed he organized the operation, financed the shipment, and coordinated corrupt officials. The scale of the importation and Budiman's history of continued operations while imprisoned justified the maximum penalty. In May 2012, court records confirm that the court found Budiman guilty and sentenced him to death. The judgment emphasized the quantity involved and the harm to Indonesian society. Court records show that the court system's consistent rejection of Budiman's appeals reflected Indonesian judicial commitment to enforcing death sentences for major traffickers. Reports indicate that Budiman appealed his conviction and sentence multiple times. He challenged the verdict at higher courts, arguing procedural errors and disproportionate sentencing. In 2016, Budiman appeared at the Cilacap District Court for a case review hearing. When asked about facing execution, news reports indicate that he stated, "If I face execution tomorrow, I am ready. This may be for the best. God is great." Court records show that his final legal options included a judicial review before the Supreme Court of Indonesia. In June 2016, Budiman's legal team argued once more that the death sentence was unjust, given the sentences imposed on co-defendants. The Supreme Court rejected the appeal. Following the Supreme Court's rejection of his final appeal, official records confirm that Budiman exhausted his legal options. The Indonesian government placed him in isolation at Batu Prison on Nusa Kambangan Island. In July 2016, reports reveal that Budiman wrote a personal letter seeking clemency from President Joko Widodo. His lawyer, Untung Sunario, traveled to Jakarta to deliver the letter. His attorney states that Budiman expressed remorse and asked for forgiveness from President Widodo, the national police chief, and the Attorney General. However, official statements confirm that Indonesia's Attorney General's office had already stated that all legal requirements for executions had been met. The government announced that 14 death row inmates, including Budiman, would be executed. The condemned individuals came from multiple countries: Indonesia, Nigeria, Zimbabwe, Pakistan, India, and China. Statements from international organizations show that human rights groups protested the planned executions. The European Union, Amnesty International, and the United Nations appealed to Indonesia to halt the death sentences. The Indonesian government rejected these appeals, maintaining that harsh penalties were necessary. Reports confirm that public protests and international diplomatic pressure failed to prevent Budiman's execution, as the Indonesian government prioritized its domestic policy over external criticism. On July 28, 2016, reports indicate that Budiman's family received final notification. Family members and lawyers visited Budiman on Nusa Kambangan Island for last goodbyes. His attorney states that Budiman requested that his body be buried in Surabaya, his birthplace in East Java. In the early hours of July 29, 2016, News reports indicate that heavy rain fell on Nusa Kambangan Island. Despite the weather, preparations for executions continued at Panaluan Field. Originally, 14 inmates were scheduled for execution that night. However, official statements confirm that only 4 would ultimately face the firing squad. At 12:45 a.m. local time, official records show that Freddy Budiman, age 37, was the first to be executed. Prison officials brought him to the field where a squad of officers waited. Official records confirm that Budiman was followed by 3 Nigerian nationals, Humphrey Ejike Eleweke, Michael Titus Igwe, and Sek Osmane, who held a Senegalese passport. All 4 men had been convicted of serious trafficking offenses. Official statements reveal that Assistant Attorney General for General Criminal Conduct, Noor Rahmad, confirmed the 4 executions later that morning. When asked about the 10 other condemned inmates who had not been executed, Rahmad stated that the government had not yet determined when their sentences would be carried out. Reports confirm that Budiman's body was transported from Nusa Kambangan Island that morning. An ambulance ferried his remains across to Wijayapura Pier in Cilacap, then on to Surabaya for burial, as he had requested. Investigations reveal that Budiman's execution did not resolve systemic problems within Indonesia's correctional system, and the seizure of 39 billion rupiah from his network after his death proved that the organization's infrastructure survived. Statements from international organizations confirm that the executions sparked criticism. Amnesty International condemned Indonesia's use of the death penalty. The European Union called the executions a violation of human dignity and urged Indonesia to join the global trend toward abolition. In June 2017, the National Narcotics Agency reported that nearly a year after Budiman's execution, authorities announced they had seized 39 billion rupiah and assets from 4 suspects connected to Budiman's network. Reports indicate that one suspect operated from inside Cipinang Penitentiary. The investigation revealed that Budiman's organization had continued functioning even after his death. If you're still watching at this point, make sure you're subscribed. We cover cases like this every week, and your support helps us keep going. While Freddy Budiman's corruption exposed Indonesia's broken prison system, the next cases show what happens when an entire country builds its policy on mandatory death sentences that leave no room for mercy. Case 3. Rosman bin Abdullah, Singapore. Rosman bin Abdullah was born on February 19, 1969, in Singapore. He spent most of his 55 years in the city-state, navigating a life marked by economic hardship and substance problems. On March 20, 2009, police reports revealed that authorities arrested Rosman for trafficking 57.43 grams of a controlled substance. Under Singapore's Misuse of Drugs Act, trafficking any amount exceeding 15 grams triggers a mandatory death sentence. Rosman's quantity was nearly 4 times that threshold. Singapore's Central Narcotics Bureau states that 57.43 grams could supply approximately 690 individuals for 1 week. Court records show that Rosman was convicted on September 14, 2010, and sentenced to death. Under Singapore law at that time, judges had no discretion in sentencing for trafficking above the capital threshold. The mandatory death penalty meant that once convicted, Rosman's fate was sealed. He would spend the next 14 years on death row, becoming Singapore's longest-serving condemned inmate by the time of his execution. On November 22, 2024, at dawn, official records confirm that Rosman bin Abdullah was executed by hanging at Changi Prison, marking the 8th execution carried out in Singapore that year. Available records indicate that Rosman's path to death row began with his involvement in Singapore's illegal trade. What is known is that by 2009, Rosman possessed a quantity that exceeded personal use levels by a substantial margin. United Nations human rights experts who reviewed his case note that Rosman had a history of certain disabilities and substance dependence. These conditions affected his capacity and judgment. Economic circumstances likely played a role in Rosman's involvement. However, Singapore law established that these distinctions carried little weight. The mandatory sentencing system focused on the quantity involved, rather than the individual's role within networks. Whether Rosman acted as a courier for others or operated independently, the law required the same sentence once he crossed the threshold for capital punishment. Human rights organizations state that Rosman's personal circumstances raised questions about the appropriateness of capital punishment in his case. But Singapore's legal framework left no room for these considerations during sentencing. Police reports confirmed that the quantity found in Rosman's possession determined his legal fate. Singapore's Misuse of Drugs Act establishes clear thresholds for different levels of punishment. Trafficking 15 grams or more automatically triggers capital charges. Rosman possessed 57.43 grams, placing him well into death penalty territory. Police arrested Rosman on March 20, 2009. Court documents indicate that evidence suggested he intended to traffic the substances rather than possess them for personal use. Under Singapore law, possession of large quantities creates a presumption of trafficking intent. Prosecutors charged Rosman under provisions of the Misuse of Drugs Act that mandate death sentences. The legal process moved forward with the understanding that conviction would automatically result in capital punishment. Legal experts note that Singapore's mandatory death penalty system treated Rosman's case as a matter of meeting threshold quantities rather than examining individual circumstances. Court procedures reveal that the mandatory nature of Singapore's death penalty meant that the trial focused primarily on guilt or innocence, rather than on what sentence might be appropriate. Defense attorneys could not argue for leniency based on Rosman's personal circumstances. Following his arrest in March 2009, court records show that authorities processed Rosman through Singapore's judicial system. He was formally charged with trafficking in quantities that exceeded the capital threshold. Court records confirm that Rosman's case proceeded to trial in Singapore's High Court. On July 16, 2010, the court convicted him of trafficking. The judge had no choice but to impose the mandatory death sentence. Rosman was 41 years old at the time of sentencing. After conviction, prison protocols indicate that Rosman was transferred to Singapore's death row, which is located at Changi Prison. Death row inmates in Singapore are held in isolation. This isolation can last for years, while appeals proceed through Singapore's court system. Reports reveal that Rosman initially faced execution in February 2022. His family received a death warrant. However, just before the execution date, authorities granted a stay. The delay came during a period when Singapore faced international pressure. However, the stay proved temporary. Official records confirm that Rosman spent approximately 14 years on death row, making him Singapore's longest-serving condemned inmate at the time of his execution. In November 2024, reports indicate that Rosman received his second death warrant. This time, the execution would proceed. Family members were notified on November 15, 2024, that Rosman would be executed on November 22, 2024. Prosecution evidence reveals that the case against Rosman centered on physical evidence. Police had seized 57.43 grams from Rosman at the time of his arrest. In Singapore's legal system, possession above certain thresholds creates a presumption of trafficking. Court records show that Rosman provided statements regarding the substances during police interrogation. However, his statements apparently did not successfully establish that they were for personal use only. Defense arguments note that attorneys raised concerns about the interrogation process. United Nations human rights experts later stated they were gravely concerned that Rosman did not appear to have had access to accommodations for his disabilities during interrogation or trial. Legal observers note that the straightforward nature of evidence in Rosman's case reflected Singapore's prosecution system, which prioritizes quantities over investigations into criminal networks. Available records indicate that the investigation did not focus extensively on Rosman's role within larger networks. Singapore's approach to prosecutions emphasizes the quantity possessed rather than elaborate investigations into organizations. Court procedures show that Rosman's trial took place in Singapore's High Court before a single judge. Singapore does not use juries for criminal trials. Trial records indicate that the prosecution presented evidence about the substances seized from Rosman and established that the quantity exceeded the 15-gram threshold that triggers mandatory capital punishment. Defense attorneys faced significant challenges because Singapore's legal framework at the time provided no avenue for arguing circumstances during sentencing. On September 14, 2010, court records confirm that the High Court found Rosman guilty of trafficking and imposed the mandatory death sentence. The conviction was based on the quantity and the presumption that possession of such a large amount constituted trafficking. Rosman was 41 years old at the time of sentencing. Appellate records show that Rosman appealed his conviction to Singapore's Court of Appeal. On April 26, 2011, the Court of Appeal dismissed his appeal, upholding both the conviction and the death sentence. Court records confirm that Rosman's decade of legal challenges failed to overturn his conviction or prevent his execution, reflecting the limited success rate of appeals in Singapore's capital punishment system. Following the unsuccessful appeal, legal procedures indicate that Rosman filed for clemency with Singapore's president. However, presidential clemency is extremely rare in Singapore. In 2012, legal reforms revealed that Singapore amended its laws to remove the mandatory death penalty in certain circumstances. Rosman applied for resentencing under this new framework. However, in September 2015, court records show that the High Court rejected Rosman's application. The court determined that he did not meet the criteria for the discretionary sentencing provisions. After exhausting his legal appeals, official records confirm that Rosman faced execution. In November 2024, authorities issued his death warrant. The decision to proceed with the execution came despite international appeals for clemency. A statement from the United Nations Office of the High Commissioner for Human Rights reveals that UN experts emphasized that Rosman had a record of disabilities and argued that he did not appear to have received accommodations during his interrogation or trial. Amnesty International also protested the scheduled execution. Chiara San Giorgio, Amnesty's death penalty expert, stated, "The upcoming execution of Rosman bin Abdullah underlines the chilling determination of the Singapore authorities to continue to implement the death penalty." A statement from the European Union shows that the organization issued a joint statement signed by EU member states, Norway, Switzerland, and the United Kingdom. The statement appealed to Singapore to abolish capital punishment. Reports confirmed that international opposition to Rosman's execution highlighted growing criticism of Singapore's continued use of capital punishment. But the government proceeded with the sentence despite diplomatic pressure. Official statements reveal that Singapore's government rejected these appeals. The Central Narcotics Bureau issued a statement emphasizing that Singapore has strict laws and that capital punishment is necessary. Reports indicate that Rosman's execution was scheduled for dawn on November 22, 2024. In the days before, family members made final visits to Changi Prison. On November 22, 2024, at approximately 6 a.m., official records confirm that Rosman bin Abdullah was executed by hanging at Changi Prison. He was 55 years old. The Central Narcotics Bureau confirmed the execution in a statement released that morning. The official statement emphasized that Rosman was accorded full due process under the law and was represented by legal counsel throughout the process. The CNB reiterated that capital punishment is imposed only for the most serious crimes. Official records show that Rosman's execution was the 8th carried out in Singapore during 2024. Earlier that month, on November 15th, 2 other condemned inmates had been executed for trafficking. Rosman's execution was followed on November 29th by the execution of Masood Rahini bin Mirzad, a 35-year-old individual convicted of trafficking 31.14 grams. Statements from human rights organizations revealed that Amnesty International stated that Singapore's continued use of the death penalty demonstrated the government's disregard for international human rights standards. Legal observers note that Rosman's death highlighted ongoing debates about the death penalty's effectiveness and raised questions about how Singapore's legal system addresses mental health issues in capital cases. On November 26, 2024, news reports indicate that 4 days after Rosman's execution, Singapore's government issued a correction order. The order targeted an activist group for social media posts claiming that Rosman had disabilities that should have precluded his execution. Official records confirm that since resuming executions in March 2022, Singapore has executed 24 individuals as of Rosman's execution. Most of these executions were for trafficking offenses. Before we continue, hit subscribe if you appreciate deep dives into cases that don't get the attention they deserve. Rosman bin Abdullah spent 14 years on death row before Singapore finally executed him. But the next condemned man didn't even get that long before the government decided to break its execution pause with his hanging. Case 4. Abdul Kahar bin Uthman, Singapore. Abdul Kahar bin Uthman was born in 1954 in Singapore. He grew up in Henderson as the eldest son in a family of 7 children. Economic circumstances were difficult, and Abdul Kahar faced struggles that would span his entire life. In 2013, court records reveal that a court convicted Abdul Kahar of 2 charges of trafficking a total of 66.77 grams. Under Singapore's Misuse of Drugs Act, this quantity placed him well above the 15-gram threshold that triggers mandatory capital punishment. In February 2015, official records show that the High Court sentenced him to death. Abdul Kahar spent 7 years on death row before authorities finally scheduled his execution. Reports indicate that his case became entangled with broader debates about Singapore's death penalty, particularly during the health crisis when the country had paused executions. On March 30, 2022, official records confirm that Abdul Kahar was executed by hanging at Changi Prison. He was 68 years old, making him one of the oldest individuals executed in Singapore's modern era. His execution marked the end of more than 2 years without executions in Singapore. Human rights activists state that Abdul Kahar's death sentence and eventual execution came despite appeals from those who argued that his life of poverty, problems, and repeated incarceration demonstrated a need for rehabilitation rather than execution. Available accounts indicate that Abdul Kahar's involvement in Singapore's illegal trade emerged from a life marked by hardship. He struggled with substance dependence for many years. Economic circumstances made legitimate opportunities scarce. Throughout his adult life, reports show that Abdul Kahar cycled in and out of prison. Each incarceration was supposed to provide an opportunity for rehabilitation. However, when released, he faced barriers to employment due to his criminal record. Accounts from his family and advocates reveal that Abdul Kahar experienced poverty and hunger during his childhood. Without education or job skills, and later burdened by a criminal record and ongoing problems, Abdul Kahar had limited options. Observers note that Abdul Kahar's background reflected a pattern common among many offenders: childhood poverty, substance problems, repeated imprisonment, and inability to reintegrate into society after each release. Court documents show that police found him in possession of 66.77 grams. The quantity exceeded personal use levels significantly. Under Singapore law, the distinction between possession and trafficking hinges partly on quantity. Police reports confirm that the substances found in Abdul Kahar's possession placed him squarely within Singapore's capital punishment framework. At 66.77 grams, the quantity was more than 4 times the 15-gram threshold that triggers mandatory death sentences. Prosecutors charged Abdul Kahar with 2 counts of trafficking, each charge related to separate portions of the total quantity. Court procedures reveal that the mandatory nature of Singapore's death penalty meant that once Abdul Kahar was charged with capital trafficking offenses, the trial focused on guilt or innocence rather than on what punishment might be appropriate. Legal observers note that the automatic nature of Singapore's death penalty meant Abdul Kahar's fate was determined by the amount found, rather than by any consideration of his role or circumstances. Government policy establishes that Singapore's approach emphasizes deterrence through harsh punishment. The government's position holds that making examples protects society from harm. Following his arrest in 2013, court records show that Abdul Kahar faced trial in Singapore's High Court. The prosecution presented evidence about the substances seized from him. Court records confirm that the trial resulted in conviction on both trafficking charges. In February 2015, the High Court imposed the mandatory death sentence. Abdul Kahar was 61 years old at the time of sentencing. After conviction, authorities transferred him to death row at Changi Prison. Appellate procedures reveal that Abdul Kahar filed appeals challenging his conviction and sentence. The Court of Appeal upheld Abdul Kahar's conviction and death sentence. Legal procedures indicate that following this unsuccessful appeal, Abdul Kahar petitioned Singapore's president for clemency. However, successful clemency applications are extremely rare. Observers note that the 7-year delay between Abdul Kahar's sentencing and his execution reflected the uncertainty that death row inmates face in Singapore. Official records show that Abdul Kahar's clemency petition was denied. At this point, he had exhausted all legal options. He remained on death row, while Singapore's government determined when to schedule executions. In March 2022, reports indicate that 7 years after his sentencing, Abdul Kahar's family received a letter dated March 23rd, informing them that his execution had been scheduled for March 30th. The short notice gave family members 1 week. Prosecution evidence shows that the case against Abdul Kahar centered on physical evidence. Police had seized 66.77 grams from Abdul Kahar at the time of his arrest. Court documents confirm that Abdul Kahar's history of substance problems was documented, but did not constitute a legal defense. Singapore's courts have consistently held that personal substance use does not excuse possession of quantities that suggest trafficking intent. Legal observers note that evidence in Abdul Kahar's case followed the pattern typical of Singapore's prosecutions: straightforward proof of possession above thresholds. Available records indicate that there is no indication that Abdul Kahar was connected to larger organizations or operated as anything more than a low-level participant. Court procedures reveal that Abdul Kahar's trial took place in Singapore's High Court. The proceedings focused on whether prosecutors could prove that Abdul Kahar possessed the substances and that the quantity met the definition for trafficking. Court records show that the court convicted Abdul Kahar of both trafficking charges in 2013. The conviction meant that the mandatory death penalty automatically applied. In February 2015, official records confirm that the High Court formally sentenced Abdul Kahar to death. He was 61 years old. Appellate procedures indicate that Abdul Kahar appealed his conviction to Singapore's Court of Appeal. The Court of Appeal rejected Abdul Kahar's appeal, upholding both his conviction and the death sentence. Court records show that Abdul Kahar's unsuccessful appeals reflected the limited success rate of challenges to trafficking convictions in Singapore. Legal procedures confirm that the president, acting on advice from the cabinet, denied Abdul Kahar's clemency petition. This decision left Abdul Kahar with no further legal recourse. After Abdul Kahar's clemency petition was denied, reports indicate that he remained on death row awaiting execution. In March 2022, Singapore had not carried out any executions for more than 2 years due to the health crisis. On March 23, 2022, reports show that Abdul Kahar's family received notification that his execution had been scheduled for March 30, 2022, 1 week away. The timing was significant. The execution would take place 3 days before Ramadan, the Muslim holy month of fasting. Amnesty International confirms that the announcement sparked immediate protests. The organization issued a statement calling the execution a shameful breach of international law. Official decisions confirm that the rejection of clemency and the decision to proceed with execution demonstrated Singapore's commitment to its capital punishment policy, despite substantial international criticism. The United Nations Human Rights Office expressed concern about a potential increase in execution notices. The European Union issued a statement calling on Singapore to halt Abdul Kahar's execution. Human rights activist Kirsten Han reports that she and Kokila Annamalai visited Abdul Kahar during his final days. Han reported that Abdul Kahar told them he wanted to live. Despite international appeals and local advocacy, official decisions reveal that Singapore's government proceeded with the execution. In the early morning hours of March 30th, 2022, reports indicate that activists held a candlelight vigil outside Changi Prison. The small gathering, led by Kirsten Han and fellow activists, took place on the pavement near the prison complex. At dawn on March 30th, 2022, official records confirm that Abdul Kahar bin Othman was executed by hanging at Changi Prison. He was 68 years old. His execution marked the first time Singapore had carried out a death sentence since November 2019. Official statements show that the Central Narcotics Bureau confirmed Abdul Kahar's execution. The announcement emphasized that he had been accorded full due process under law. Reports indicate that Abdul Kahar's body was released to his family shortly after the execution. His brother claimed the body, and the family held a funeral. In a statement released after Abdul Kahar's death, family members remembered him as a gentle older brother, a doting uncle, a loving son. Observers note that Abdul Kahar's execution, as Singapore's first after the pause, established that the government intended to continue applying capital punishment. Statements from international organizations reveal that responses to the execution divided along predictable lines. International human rights organizations condemned the decision. Singapore's government defended the execution as necessary. Official records confirm that Abdul Kahar's execution had immediate implications for other death row inmates. The day before Abdul Kahar was executed, the Court of Appeal dismissed the final appeals of Nagenthran K. Dharmalingam. The court's ruling cleared the way for Nagenthran's execution, which was carried out 3 weeks later. Official statistics show that in the months following Abdul Kahar's execution, Singapore executed several more condemned inmates. By the end of 2022, 11 executions had been carried out, all for trafficking offenses. Make sure to subscribe before the next case. Trust me, it's even more shocking than what you just heard. Abdul Kahar bin Othman was at least a Singaporean citizen executed by his own country. But the next case involves a young Australian tourist who made one terrible decision and paid for it with his life, despite his government's desperate attempts to save him. Case 5. Nguyen Tuong Van, Singapore. Van Tuong Nguyen was born on August 17, 1980, in a refugee camp at Songkhla, Thailand. His parents were Vietnamese refugees who fled their country. Van and his twin brother, Dang Quan Nguyen, were born into this situation. The family eventually relocated to Melbourne, Australia, where the brothers grew up in a Vietnamese-Australian community. Reports indicate that Van did not know his father until 2001. The family maintained connections to their Vietnamese heritage while building a life in Australia. Van worked as a salesman. By his mid-20s, he appeared to be a typical young Australian. In December 2002, Van's later statements revealed that he traveled to Cambodia on what he claimed was an attempt to help his twin brother Quo pay off debts. Van stated that Quo owed approximately 22,000 Australian dollars to lenders in Sydney who were threatening violence. Van's account claims he agreed to transport substances from Cambodia to Australia to clear this debt. On his return journey, police reports show that Van passed through Singapore's Changi Airport during a layover. Airport security detected 396 grams strapped to his back and hidden in his backpack. Singapore police arrested him immediately. Under Singapore's Misuse of Drugs Act, trafficking more than 15 grams carries a mandatory death sentence. Van possessed more than 26 times that amount. On December 2, 2005, at 6:06 a.m. Singapore time, Official records confirm that Van Tuong Nguyen was executed by hanging at Changi Prison, making him the first Australian citizen executed in Southeast Asia since 1993. Available records indicate that Van's involvement in trafficking was not the result of a criminal career. He had no prior convictions. His decision to transport substances represented what he later described as a desperate attempt to resolve what he perceived as a threatening situation for his twin brother. Van's account claims that his brother, Quo, had accumulated significant debt to lenders operating in Sydney. These lenders allegedly threatened violence against Quo if the debt was not repaid. Van claimed that he felt responsible for protecting his brother. In late 2002, reports indicate that Van traveled to Phnom Penh, Cambodia. Court documents reveal that Van obtained 396 grams and prepared to transport it to Australia. He concealed the substances poorly, wrapping them and attaching them to his body and placing additional packages in his backpack. Observers note that Van's lack of criminal background and the circumstances of his arrest suggested he was a desperate individual making a poor decision rather than a career criminal. Security reports confirm that Van's lack of experience became apparent in how he attempted the smuggling. His route took him through Singapore, one of the world's most aggressive enforcement jurisdictions. Police reports show that airport security at Changi detected the substances during Van's layover. He was attempting to board a Qantas flight to Melbourne when authorities arrested him. Singapore police processed Van into custody and charged him with trafficking. Police reports confirm that the quantity found in Van's possession determined his legal fate immediately. At 396 grams, Van possessed more than 26 times the 15-gram threshold that triggers Singapore's mandatory death penalty. Singapore authorities state that this amount was sufficient to supply approximately 26,000 individuals. Prosecutors charged Van under the Misuse of Drugs Act. The charges specifically alleged importing controlled substances into Singapore with intent to traffic. Court procedures reveal that the case proceeded to Singapore's High Court for trial. Before the trial began, Van's defense team sought unsuccessfully to have him admitted to the Singapore Supreme Court as a lawyer, hoping to mount his own defense. This application was denied. Legal observers note that the automatic application of the death penalty meant that Van's conviction was effectively equivalent to his execution unless he received clemency from Singapore's president. Prosecutors made clear during trial preparation that they would enforce the mandatory death sentence if Van was convicted. Singapore's Attorney General emphasized that the law required execution for trafficking above the threshold quantity. Defense strategies reveal that attorneys faced significant challenges. Van had been caught with the substances in his possession, making the basic facts difficult to contest. Following his arrest at Changi Airport in December 2002, court procedures show that Van was detained and processed through Singapore's criminal justice system. By March 2004, Van faced trial in Singapore's High Court. Court procedures confirm that the trial proceeded before a single judge without a jury. The prosecution presented evidence about the substances seized from Van. Court documents show that Van did not contest that he possessed the substances. Defense arguments reveal that attorneys presented evidence about Van's background, his relationship with his brother, and the circumstances that led him to attempt trafficking. Defense attorneys emphasized that Van had no criminal record. In March 2004, court records confirmed that the High Court found Van guilty of trafficking. The conviction required the judge to impose the mandatory death sentence. Van was 23 years old at the time of his conviction and sentencing. After the trial, Van was transferred to death row at Changi Prison. Court procedures show that Van's trial and appeals followed the standard trajectory for capital trafficking cases in Singapore, with mandatory sentencing leaving no room for judicial discretion. Appellate records reveal that Van immediately appealed his conviction to Singapore's Court of Appeal. The appeal challenged various aspects of the trial proceedings, but the Court of Appeal found no errors that would warrant overturning the verdict. Van's appeal was dismissed. Following the unsuccessful appeal, legal procedures indicate that Van's legal team filed a clemency petition with Singapore's president. This represented Van's final opportunity to avoid execution. After Van's sentencing, reports show that supporters in Australia and Singapore mobilized to seek clemency. The case attracted significant media attention in Australia, where the death penalty had been abolished decades earlier. News reports confirm that Australian government officials at multiple levels appealed to Singapore for clemency. Prime Minister John Howard personally raised Van's case with Singapore's Prime Minister Lee Hsien Loong during the November 2005 Asia-Pacific Economic Cooperation Summit in South Korea. Official statements reveal that the Australian government's efforts extended beyond the Prime Minister. Foreign Minister Alexander Downer communicated with his Singaporean counterpart, George Yeo. Attorney General Philip Ruddock publicly criticized Singapore's decision to proceed with the execution. Reports indicate that religious leaders also advocated for Van. The Vatican, along with various Christian organizations in Australia, appealed for mercy. Van had converted to Catholicism and was baptized with the name Caleb while on death row. Observers note that the international campaign to save Van's life demonstrated significant grassroots support, but failed to change Singapore's government position or secure presidential clemency. Statements from human rights organizations, particularly Amnesty International, confirm that they campaigned against Van's execution. These groups argued that the death penalty for trafficking violations violated international human rights standards. In Australia, polling data reveals that public opinion was divided. A Roy Morgan research poll conducted 2 days after Van's execution found that 52% of Australians approved of the execution, while 44% opposed it. In October 2005, official records show that Singapore's president rejected Van's clemency petition. This decision left Van with no remaining legal options. The president acts on advice from the cabinet. Government statements confirm that Singapore's Prime Minister, Lee Hsien Loong, publicly defended the decision. During the November 2005 APEC summit, Lee explained Singapore's position to Australian Prime Minister Howard. Lee noted that Van was caught with a very large amount. Lee's statement reads, "We take a very serious view of trafficking. The penalty is death." In this case, it was an enormous amount, nearly 400 grams, which is the equivalent of 26,000 supplies. Official decisions confirm that Singapore's refusal to grant clemency, despite diplomatic pressure from Australia, demonstrated the government's determination to enforce trafficking penalties. Reports indicate that the Australian government briefly considered requesting a hearing at the International Court of Justice, which would have required Singapore's agreement. Foreign Minister Downer acknowledged it was unlikely Singapore would agree. The option was not pursued. In November 2005, reports show that Van's lawyers traveled to Singapore to inform him that his execution date had been set. On November 21, 2005, lawyers visited Van at Changi Prison to deliver the news that he would be executed on December 2, 2005. As December 2, 2005 approached, reports indicate that Van prepared for his death. He had converted to Catholicism while on death row and spent his final days in prayer and reflection with religious counselors. Van's lawyer, Lex Lasry, described Van as calm in the final hours. Reports confirm that Van's family traveled to Singapore for final visits. His mother, Kim Nguyen, was granted permission to visit Van multiple times during his last days. In a concession, reports show that Singapore's prison authorities allowed Van and his mother to hold hands during their final visit. However, authorities rejected requests to allow them to embrace. Reports indicate that Kim Nguyen later described these final visits as deeply painful. She told reporters she had been able to talk to Van and touch his hair and face during their last meeting. Reports show that Van's twin brother, Koa, also traveled to Singapore. On the morning of the execution, Koa and Van's lawyer arrived at Changi Prison before dawn. They could not witness the execution directly, but they wanted to be as close as possible to Van. Reports confirm that the execution proceeded despite international protests and diplomatic efforts, demonstrating Singapore's unwillingness to make exceptions even for foreign nationals. News reports indicate that the execution was scheduled for dawn on Friday, December 2, 2005. In Melbourne, a large church bell tolled 25 times, once for each year of Van's life, as the execution took place. Prayer vigils were held in multiple Australian cities. At 6:06 a.m. Singapore time, official records confirm that Van Tuong Nguyen was executed by hanging at Changi Prison. He was 25 years old. Singapore's Home Affairs Ministry confirmed the execution in a brief statement. Reports indicate that Van's body was released to his family approximately 4 hours after the execution. The body was taken to the Marymount Chapel at the Good Shepherd Convent in Singapore for a private memorial service. Van's family returned to Melbourne with his body on December 4, 2005. News reports confirm that a requiem mass for Van Tuong Nguyen was held at St. Patrick's Cathedral in Melbourne on December 7, 2005. Several Victorian members of Parliament attended the service. Reports indicate that Van's mother, Kim Nguyen, and his twin brother, Kwa, were devastated by the execution. Journalist Jana Wendt, who covered the case, states that ordinary Australians remembered where they were when Van was executed. Reports show that the Australian government's response to Van's execution was mixed. Liberal MP Bruce Baird requested an official minute's silence to honor Van. However, the Returned and Services League objected. The request for a parliamentary tribute was not granted. Reports confirmed that Van's case sparked debate in Australia about capital punishment. While many Australians opposed his execution, others supported Singapore's right to enforce its laws. Observers note that Van's execution remains the most recent case of an Australian citizen being executed abroad, and established that Singapore would not make exceptions to its mandatory death penalty. Reports indicate that the execution had diplomatic implications for Australia-Singapore relations. However, both governments worked to minimize any lasting damage. Australian officials expressed disappointment with Singapore's decision, but acknowledged that Singapore had the sovereign right to enforce its laws. In 2013, news reports confirmed that SBS TV produced a television drama series about Van's case called Better Man. The production brought renewed attention to Van's story. Van's lawyer, Lex Lasry, who represented Van during his final years, continued to speak about the case decades later. In 2024, Lasry wrote that people still tell him they remember where they were when Van was executed. If these stories are helping you understand the darker side of human nature, subscribe to see more cases we uncover. Van Tuong Nguyen was executed despite being a first-time offender who made one poor decision. But the final case shows what happens when someone in the exact same situation gets a second chance at life. Case 6. Yong Vui Kong, Singapore. Yong Vui Kong was born on January 23, 1988, in Sabah, Malaysia. He grew up as one of 6 siblings in a family that faced economic challenges. Yong came from a state in Malaysia known for poverty and limited opportunities. At age 19, police reports reveal that Yong worked as a courier for an individual. On June 12, 2007, Singapore police arrested him with 47.27 grams in his possession. Under Singapore's Misuse of Drugs Act, this quantity exceeded the 15-gram threshold that triggered mandatory capital punishment. Yong was too young to drink or vote in Singapore, where the age of majority is 21 years. But he was old enough to face execution. Accounts indicate that Yong was not aware of Singapore's death penalty for trafficking. He reportedly did not know what the package he carried contained. His role as a low-level courier reflected a common pattern in trafficking networks. In November 2008, court records show that a Singapore court found Yong guilty and sentenced him to death. The trial judge, Justice Chu Han Tek, recognized Yong's youth and circumstances. Before sentencing, court transcripts reveal that Judge Chu asked prosecutors to consider reducing the charge. The prosecution declined. The judge had no choice but to impose the mandatory death sentence. Legal observers note that Yong Vui Kong's case would become one of the most significant death penalty cases in Singapore's modern history, eventually contributing to legal reforms that ended mandatory capital punishment for some offenses. Reports indicate that Yong grew up in Sabah, a Malaysian state on the island of Borneo. Economic opportunities in Sabah are limited compared to more developed parts of Malaysia. Yong's family circumstances made finding stable employment difficult. At some point before his arrest, police reports show that Yong became involved with a criminal organization. However, his role was clearly that of a low-level courier. Court documents reveal that Yong worked for an individual named Chia Chun-Leng. This person remained largely in the background, while operatives like Yong took the risks. The arrangement is typical of trafficking networks. On June 12, 2007, police reports confirmed that Yong entered Singapore carrying 47.27 grams. He was 19 years old at the time. Singapore police arrested him during an operation. The quantity Yong carried was more than 3 times the threshold that triggered Singapore's mandatory death penalty. Legal observers note that the contrast between Chia's discharge and Yong's death sentence highlighted disparities in how Singapore's legal system treated different participants in trafficking operations. Following Yong's arrest, court records show that Singapore authorities also arrested Chia Chun-Leng. Prosecutors charged Chia with trafficking. However, in a decision that would later become controversial, the Attorney General's office gave Chia a discharge not amounting to acquittal. This meant Chia was not convicted and did not face punishment, while Yong faced mandatory execution. Police reports confirm that the substances found in Yong's possession placed him squarely within Singapore's capital punishment framework. At 47.27 grams, the quantity exceeded the 15-gram threshold by more than 3-fold. Prosecutors filed trafficking charges against Yong under the Misuse of Drugs Act. Singapore law presumes that anyone possessing controlled substances above certain quantities intends to traffic them. Court procedures reveal that the mandatory nature of the death penalty meant that once charged and convicted, Yong's execution was automatic unless he received clemency from Singapore's president. The trial would focus on guilt or innocence. Observers note that Yong's youth and limited role created sympathies that would later fuel campaigns to save his life and reform Singapore's mandatory death penalty system. Court procedures show that during trial preparations, Yong's circumstances raised concerns. He was only 19 years old, below Singapore's age of majority of 21. He had worked as a courier for someone else. The trial judge would later acknowledge these factors by asking prosecutors to consider reducing charges. Court records confirm that Yong's trial took place in Singapore's High Court before Justice Chu Han Tek. The evidence against Yong was straightforward. Police had arrested him with 47.27 grams in his possession. Trial transcripts show that Yong did not contest that he had been carrying the substances. Before imposing sentence, court transcripts reveal that Justice Chu took an unusual step. The judge directly addressed prosecutors and asked them to consider reducing the charge. Justice Chu noted Yong's young age and his apparent role as a courier. Court records show that the prosecution declined Justice Chu's suggestion. Prosecutors maintained that the quantity involved justified the most serious charge. Left with no alternative, Justice Chu convicted Yong and imposed the mandatory death sentence on November 14, 2008. Following his conviction, appellate procedures indicate that Yong filed an appeal with his lawyer. However, Yong withdrew his appeal on April 29, 2009, the day the Court of Appeal was scheduled to hear it. The withdrawal appeared to be based on a mistaken belief that previous court decisions foreclosed any possibility of success. Reports confirm that the last-minute intervention by M. Ravi saved Yong's life just 2 days before his scheduled execution, and began a legal battle that would span several more years. After withdrawing his appeal, legal procedures show that Yong petitioned President S.R. Nathan for clemency on August 11, 2009. However, on November 20, 2009, official records confirm that the president denied the petition. With his clemency petition denied, official records show that Yong's execution was scheduled for December 4, 2009. 2 days before this date, human rights lawyer M. Ravi took over Yong's case. Court records reveal that Ravi immediately filed an emergency application seeking a stay of execution. The court granted the stay. Legal arguments show that Ravi argued that Yong had withdrawn his appeal under the mistaken belief that he could not challenge the constitutionality of the mandatory death penalty. On December 8, 2009, court records confirm that the Court of Appeal accepted Ravi's argument. The court agreed to restore Yong's appeal for hearing. Court procedures reveal that the restored appeal was heard on March 15, 2010. Ravi argued that Singapore's mandatory death penalty violated Articles 9.1 and 12.1 of the Singapore Constitution. Before the Court of Appeal delivered its judgment, news reports indicate that Minister for Law K. Shanmugam commented publicly on Yong's case. Speaking at a community event on May 9, 2010, reports show that Shanmugam was asked whether Yong's case would affect Singapore's laws. The minister replied, "Yong Vui Kong is young. But if we say, we let you go, what's the signal we're sending?" Legal observers note that the Court of Appeal's decision affirmed the constitutionality of Singapore's mandatory death penalty, but also established that Yong had exhausted his legal options through normal appellate channels. Critics argued that Shanmugam's public comments while the appeal was pending generated controversy. Critics stated that a government minister should not comment on active legal proceedings. On May 14, 2010, court records confirm that the Court of Appeal issued its judgment. The three-judge panel ruled against Yong on all constitutional grounds. The court held that the mandatory death penalty did not violate Articles 9.1 or 12.1 of the Constitution. The court's opinion emphasized that the threshold of culpability in imposing the mandatory death penalty for trafficking offenses was a matter of policy. Following the unsuccessful constitutional challenge, legal procedures show that Ravi filed additional legal challenges on Yong's behalf. In March 2012, Ravi returned to the Court of Appeal with a new argument. Legal filings reveal that he alleged that the Attorney General had discriminated against Yong by charging him with capital offenses while giving Chia Chun Leng a discharge. Legal arguments note that this disparity in treatment raised serious questions about prosecutorial discretion. Ravi argued that punishing the low-level courier with death while letting the organizer go free violated principles of equal protection. Court procedures show that the Court of Appeal heard Ravi's discrimination arguments on April 4, 2012. However, the court found that Ravi had not produced sufficient evidence to prove the Attorney General acted with bias. Legal observers note that the discrimination challenge highlighted systemic concerns about how Singapore's legal system treated different participants in trafficking, but failed to provide Yong with relief from his death sentence. Court records confirm that the Court of Appeal dismissed Yong's application on April 4, 2012. This rejection meant Yong had failed in his second major challenge to his death sentence. In July 2012, government announcements revealed that Singapore's government announced it would reform the mandatory death penalty for certain offenses. Parliament would consider amendments to remove mandatory capital punishment in specific circumstances. Official statements show that the announcement represented a significant shift in Singapore's approach. For decades, the government had defended mandatory death sentences as essential to its policy. On November 14, 2012, legislative records confirmed that Singapore's parliament passed the Misuse of Drugs Amendment Act. The amendments did not abolish the death penalty, but gave courts discretion to impose life imprisonment in cases where defendants met specified criteria. The changes also applied retroactively. Legal procedures reveal that Yong qualified for resentencing under the new law. He had worked as a courier rather than organizing operations. His role met the statutory definition that would permit a life sentence instead of execution. Yong's case was sent back to the original trial judge, Justice Chu Han Tek, for review. Legal observers note that Yong's successful resentencing proved that Singapore's legal reforms created a genuine pathway for some death row inmates to avoid execution, though the restrictive criteria meant many others remained under sentence of death. In November 2013, court records show that Justice Chu Han Tek conducted the resentencing hearing. The judge reviewed evidence about Yang's cooperation with authorities and his role as a courier. After considering the evidence under the amended law, Justice Chu commuted Yang's death sentence to life imprisonment and caning. Legal observers note that the commutation marked a landmark moment in Singapore's legal history. Yang became the first person sentenced to death under Singapore's trafficking laws to have his sentence reduced to life imprisonment. Following his resentencing to life imprisonment, prison procedures show that Yang was transferred from death row to the general prison population. Under Singapore law, life imprisonment means incarceration for the rest of a person's natural life, with potential for parole after serving at least 20 years. Official calculations reveal that Yang's parole eligibility date is June 2027, accounting for time served since his arrest in 2007. At that time, prison authorities will review his conduct. Reports indicate that while in prison, Yang devoted himself to Buddhism and learned to speak English. He expressed hope that he could counsel youth about dangers during his imprisonment. Observers note that Yang's case played a crucial role in Singapore's decision to reform its death penalty laws. The international attention his case attracted, combined with domestic advocacy, created pressure that contributed to the 2012 legal amendments. Observers note that Yang's case represents both the possibility of reform and its limitations. His life was saved, demonstrating that legal systems can evolve, but the reforms came too late for those executed before 2012. In 2010, reports show that a Save Vui Kong campaign was formed jointly by human rights organizations. On August 24, 2010, reports confirm that a petition bearing 109,346 signatures gathered from petitioners in Sabah, other parts of Malaysia, Singapore, and online was delivered to the president's official residence. Reports indicate that M. Ravi, the human rights lawyer who took over Yang's case in December 2009, continued to use Yang's story in arguments for abolishing capital punishment. Legal analysis reveals that the 2012 legal reforms that saved Yang's life had mixed results for other death row inmates. While some prisoners successfully applied for resentencing, others were denied. Official records show that only 4 people had their death sentences commuted in 2013, with Yang's case being the first related commutation. Reports confirm that Yang remains incarcerated as of 2025, having spent more than 17 years in Singapore's prison system since his 2007 arrest. His potential release on parole in 2027 would mark 20 years since his arrest. However, parole is not guaranteed. Observers note that the contrast between Yang's ultimate fate and the death sentences carried out on others convicted of similar or lesser offenses highlights how legal reforms created a two-tier system. If you enjoyed this deep dive into major individuals on death row, make sure to subscribe. I'll see you in the next video.